Thank you back, ladies and gentlemen. We have a new official controls regulation, and it is rather big. It will not be possible to cover all of it in half an hour. So I would like to focus on those elements that are important for what I call here the primary process of enforcement. So the relation between public authorities and different stakeholders in controls and in enforcement. And I will follow the different steps, starting from enforcement relations, short remark on why we have this new piece of legislation, what is its scope, something on controls, something on investigation, something on measures in case of non-compliances, something on penalties. And then I will try to cover the whole area again from specific perspectives, what I call these special topics. So perspectives of food fraud, of online enforcement, position of operators, of witnesses and consumers. So there's a lot that has to be left out, although very interesting issues such as the fees, imports, the laboratory infrastructure, audits, administrative cooperation, related systems, etc. When we think of enforcement, we tend to primarily think of a competent authority in relation to a food business operator regarding the question of compliance or non-compliance. In this picture, I tried to express that more stakeholders may be involved. The food business stands in direct relations to customers, often consumers. The food business is the one that is addressed by the norm of which compliance is tested. Often the consumer will be the one protected by that same norm. Compliance or non-compliance will also relate to knowledge about what actually has taken place. So in the other corner I placed the witness, and the one witness that the new regulation specifically is interested in is the whistleblower, the person from the circle of the business who provides information. And of course, the public at large plays a role, has an interest, and may also be informed in certain situations. On this slide, I spelled out in detail, but I'm not going to read it, the official title of this new official controls regulation. It was published a little over a year ago, 7 April in 2017, and most of it will be applicable starting 27 April 2019. Why was there a need for a new regulation? If I'm all honest, I'm not entirely convinced that there was a need for a new regulation. In the context of refit, in the context of legislation in general, I always keep in mind that on the very first empirical study that we did on how food law is perceived, businesses indicated, well, at the end of the day, we can live with any kind of legal system. The biggest challenge is in the changes. Limit the changes of the law to the real necessities. Therefore, you would expect a real problem assessment that results in an urgency. Well, the reasons given in the recitals are about rationalization, simplification of the legislation. Therefore, it is twice as big as its predecessor. Partly also because some other pieces of information of legislation have been integrated, but not the legislation on agricultural standards, except for situations of fraud from the perspective of simplification. They want to harmonize, and of course there are some new developments. Trade online has developed, is in the process of developing tremendously. For some inexplicable reason, the horse meat scandal has raised awareness that all these other scandals have not raised, that there are more enemies to food safety than just microorganisms, just toxic substances, just physical objects. There are also bad people. Somehow the general food law had a blind spot for bad people, which the horse scandal has lifted and which has played its role in this new regulation. In integrating more pieces of legislation, the scope of the new official controls regulation is well beyond the scope of food law, even more than of the previous official control regulation. Article 1 in its second section lists the areas of law covered by the controls under this regulation. For us, the most interesting, of course, is food and food safety, but also food integrity, wholesomeness of food, the release of GMOs, feed safety. Then there are all kinds of issues on animal and plant health. And back in our field of interest is organics and protected designations. Where the field is broader than just food law, also the addressee can no longer be indicated as a food business operator. So the regulation uses the expression business operator, whatever business that would be. You see a certain connection of elements within the regulation, starting from official controls that have to be risk-based, and if from these controls or from any other source a suspicion of non-compliance follows, there is an obligation to investigate this suspicion, and if indeed a non-compliance is established, actions have to be taken, or measures, the words are used more or less interchangeably, to put an end to these non-compliances. And next to it, provision is in place on penalties and on union enforcement measures. The logic, one step following the other, is not as clearly present as between the other three elements. The notion that official controls should be risk-based is mainly visible in Article 9 on general rules of official controls, which puts up front a requirement that official controls should address all operators regularly. How regularly that should be is assessed on a risk basis. This risk basis is established taking into account identified risk associated to goods, which for us mainly will mean food products, activities of the businesses, the location where the business is active, products, processes, etc. And in the context of food fraud, an additional element of attention is information indicating the likelihood that consumers might be misled on all of these interesting aspects. Attention is paid to the past record of compliance by the operators, and an important, relatively new element is that in assessing the risk, the functioning or malfunctioning of the private quality assurance system and self-control systems is taken into account. Obviously, if any specific information is available about this individual situation, this is taken into account as well. Risk-based and specifically also focused on fraudulent or deceptive practices. Responding to practices in the member states, the regulation indicates that controls, as a rule, should take place without prior notice, except when it's duly justified to inform upfront. In practice, inspectors like to announce their visit to make sure that at least the people they want to talk to are actually present. EU legislator indicates that should not be the rule. And by the way, if you go there as an inspector, make sure you keep the burdens to a minimum, whatever that may mean in practice. Official controls have to be risk-based. Interestingly, the regulation has its own definition of risk, a definition that's rather close to the definition of the General Food Law, that it is a function of the probability of an adverse effects on human, animal, plant health as a consequence of a hazard. And then hazard is further defined as well. Now, if you take this definition as your starting point, then risk-based inspections, risk-based controls would mean that the property of the product would have to be your starting point. That does not sit very easily with all these elements of information available, consumers misleading, etc. So probably the definition of risk in the regulation is not very helpful in assessing what the regulation means when it says that official controls have to be risk-based. Probably risk-based here means something related to the probability of non-compliance rather than the probability of an adverse effect on health. But that's just speculation so far. The regulation provides instruments for official controls. The structure is as follows. The member states, on basis of their institutional autonomy, designate the competent authorities. But once these competent authorities in place, the regulation, on the basis of a direct effect, provides powers. And of course, probably national law provides powers to these regulators, to these control officers as well. And as far as the controls are concerned, Article 14 lists powers that are available to inspectors. The methods and techniques for official controls shall include the following as appropriate. First of all, inspectors can examine controls that operators have put in place and the results that are obtained by them. Now, if these controls consist of third-party certification schemes, the question presents itself, if this power can only be executed through the operator who is under control, or also directly through the operator of the certification scheme. At this moment in time, that is unclear. They can inspect equipment, they can inspect animals, goods, ingredients, processing aids, traceability systems, labeling, and all other kinds of information about products. They can inspect the hygiene situation and the hygiene procedures that are in place. They can seize and inspect documents. They can hold interviews with operators and their staff. They can verify self-inspections in terms of measurements and test results, but they can also do their own sampling, their own analysis, and their own tests. And as an afterthought, anything else that might do the trick is in the toolbox as well. Any other activity required to identify cases of non-compliance. I'll come back to that point a little bit later. For the specific situation of food trade online, the regulation holds some provisions. In Article 15, it indicates that business operators must inform authorities of these activities. In Article 36, it allows inspectors to engage in what the recitals call mystery shopping, to order products online without identifying themselves as inspectors. I heard German inspectors explain that it's quite a challenge to obtain a credit card for this purpose to be able to do mystery shopping. But anyway, according to European Union law, explicitly it will be allowed. Only afterwards, when the samples have been obtained, the business is informed that the sample has been taken, for which purpose it is taken, and are they informed of their right to a second expert opinion, to which we also will return later. The regulation indicates what should be the result of official controls. There should be written records. Report, the old regulation says, but for some reason difficult to fathom, the legislator decided to change the wording in almost every aspect. This written record should indicate the purpose of the control, the methods applied, the outcome, and in case certain remedies, certain actions have been required, what they are. The business who has been subject to the official control can request a copy of this written record, which they will receive, except when, for the purpose of investigation, etc., there are reasons, specific reasons to withhold it. The results, as such, are not necessarily confidential. There are two provisions addressing specifically the publication of inspection results. Article 11 in terms of ratings, so on listings of businesses based on their level of compliance. I indicated a picture of the Danish smiley system, which probably prompted the inclusion of this kind of legislation also in the Netherlands. They are currently working with website systems so that you can check how the businesses in your neighborhood are doing before you actually engage into transactions. Article 8 even seems to go a step further in the sense that it indicates that confidentiality obligations do not stand in the way to actually publish the outcome of official controls regarding individual operators. But there is only provision that the operator should be given the opportunity to make comments, and that these comments in one way or another should be taken into account. Now, if these controls or any other source leads to a suspicion of non-compliance, according to Section 2, Paragraph 2 of Article 137, then competent authorities shall perform an investigation in order to confirm or eliminate that suspicion. It is worded rather strictly. If I look at the competent authorities that I know, it would be quite a challenge to read this as a non-discretionary obligation to do an investigation in every situation where there is a suspicion of a non-compliance. We have seen in a totally different context in the Berger case that the Court of Justice is quite willing to read in these kind of wordings indeed a non-discretionary obligation. I would thoroughly hope that this line may not continue in this way. Also, Article 137 of the regulation talks about priorities in the context of enforcement, and they say that priority shall be given to action to be taken to eliminate or contain risks to human, animal health, etc. Now, what exactly does this mean? It might mean that it gives priority to the measures indicated in Article 133, the measures aiming at terminating a non-compliance over penalties. If that is indeed the intention of the regulation, that would be rather interesting, because in practice we sometimes see the opposite. That in particular in more severe cases, official competent authorities let things happen for a while in order to be able to collect sufficient evidence for criminal cases. Personally, I would be in favor indeed of this thinking. If there's a risk to health, you stop it now, and if that means that you cannot catch the bad guys, well, so be it. So those actions in Article 138, what are they? Again, shall take, where non-compliance is established, action to determine the origin, the extent, but also the responsibility. Who is responsible for the things that are going on? And then take the appropriate measures to ensure that the operator concerns remedies the situation, terminates the non-compliance, repairs must be repaired. The selection of specific measures should take into account the nature of the non-compliance and also the operator's past record. All costs of the remedies, all costs of these reparations are borne by the operators. Again, the regulation provides a list of powers that the competent authorities possess. Starting again with this very open phrasing, any measure they deem appropriate to ensure compliance with the rules referred to in this article, including but not limited to the ones that follow. And again here I ask myself the question, does this really mean that European law provides an open and unrestricted competence base to national authorities, or is it any measure under the provision that national law provides the competence to do it? It's very easy to predict that we will have a lot of discussion on particular this point where authorities will say, well, we did anything on the basis of the official regulation. Specifically mentioned powers relate to treatment of goods, to imposing an obligation to inform consumers, be it via labeling or directly or whatever, restrict the placing on the market of certain products, an obligation to increase self-controls. There is a power to order a recall of products, to close businesses, to stop certain activities, including closing internet sites. Withdrawal of registration of businesses, and somewhat outside our scope, ordering that animals shall be killed. As to recalls, we have in Article 19 of the General Food Law an obligation for businesses to recall in case of non-compliance with food safety requirements. And of course, competent authorities can enforce this obligation. Now, what does the official controls regulation here add? Is it just the enforcement of this particular obligation, or can you indeed also order a recall in situations where Article 19 does not apply? I think that is the case. And it is important, as has been shown by the very differing responses in member states to the horse meat crisis. Some countries believed that the horse fraud was within the scope of Article 19. Others believed that it was not. Among those others, there were some who had an additional power under national law. There were some that had not. Probably this provision in the official controls regulation could provide the answer. Yes, in case of a non-compliance to any rule of food law, potentially there's the option to impose a recall. After the measures to solve the problem, there is the issue of penalties, of punishing the wrongdoers. Well, we've seen it already in the general food law. They have to be effective, proportionate, and dissuasive. And then came in the situation of fraud. So here the European legislator indicates to the national legislators the level of sanctions that they should have in place in case of fraudulent or deceptive practices, at least either the economic advantage or the operator's turnover as indication of the level. Now, in a country like the Netherlands, there is the measure in place that enables authorities to seize the illegally obtained economic advantage, separate from imposing penalties. Now, an interesting question presents itself for such countries where the European legislator labels it as penalties. Can you still have it as a separate measure next to a penalty, or has it to be included in the penalties? Do I have a few minutes left for a few special topics, looking at the same thing from different angles? On different places in the regulation, the phrase is used, fraudulent or deceptive practices. These concepts are not further defined when the regulator thinks there is fraud or deception. In my view, if you want to regulate on the issue, it would have been sufficient to distinguish intentional infringements on food law from all other infringement without using words such as fraudulent and deception, which may lead to all kinds of difficulties in proving the case. Nevertheless, we find this phrase in the exception to the exception, are you following me, that marketing standards under the common agriculture policy are not covered by the regulation. If it is fraudulent or deceptive, it is covered. Fraud and deception are a risk factor in setting the priorities, as we have seen. We have seen that there should be high financial penalties, and finally there are going to be reference centers for the authenticity and integrity of the agri-food chain. Food law online, enforcement online. The elements in the regulation include that businesses have to inform what they do online, that inspectors can engage in mystery shopping, and that among the measures taken, the closure of internet sites is indicated. Now let's look at it from the perspective of operators. What are their obligations? What are their rights? In case of official controls, they are under obligation to provide access to premises, to places, to means of transport, but also access to computerized information management systems, to animals, to goods, to documents, to information. They have to assist inspectors and cooperate. I wonder if cooperating implies, the obligation to cooperate implies an obligation to speak when they are interviewed in the context of an inspection. They have to provide their name, legal entity, activities, etc., etc. There's also some attention in the regulation to rights of defense. In particular, in Article 7, it is indicated that there must be a right to appeal certain decision, and that the addressee should be informed of it. This is in the context of decisions regarding consignments, destruction of consignments, decisions in the context of investigations, decisions about action to be taken in case of non-compliance. Interestingly, the provision on penalties is not mentioned in this context. Before business-specific information is published There is a right to comment. When information that is published is wrong, there is a certain amount of right to rectification in Article 11. Businesses can request copies. Businesses have a right to a second expert opinion in the context of samples that have been taken, also online. But what is mentioned nowhere, not even in the context of these rather heavy penalties and related investigation, is a right to remain silent. Do we find this in the European Convention on Human Rights? Do we find it in national law? Or is it simply overruled by this regulation? It remains to be seen. We spoke earlier today about compliance assistance, about the importance that authorities should be willing to help those who actually want to comply with the law. We do not find a single consideration in all the 200 pages of this regulation. Probably the European legislator should look beyond the borders of the EU and find some great examples elsewhere. Private certification schemes are within the awareness of the regulation, on the one hand, to assess the level of risk that is present in the context of a certain business, and the results themselves may be subject to official controls. To make sure that more people step forward with information about non-compliances in the food sector, a whistleblower protection is required in Article 140. Member states must have mechanisms that enable reporting where they receive reports and their follow-up. I hope this means that after receiving a report, the whistleblower should be kept informed of what is being done with the information. People should be protected from any kind of retaliation, and their personal data should be protected. What about consumers? Recital 2 lays emphasis on a high level of consumer protection. Recital 74 indicates that consumer confidence must be ensured. So, are consumers given a right to complain, to request enforcement in case of an infringement of food law against them? Maybe that's a little bit included in this Article 140 on whistleblowers. I don't know, but nowhere else. Is there a right for consumers to be heard? Is there a right for consumers to get access to the file? Is there a right for consumers to be informed about decisions in the context of enforcement? Is there a right for consumers to appeal such a decision? None of these things are in the official controls regulation. If they exist in national law. They do not exist in European Union food law. Thank you.